May it please the court, Ms. Galinsky, my name is Ed Fleming, and together with Mr. Tyler Harris, we have the privilege of representing the account, which is Gulf Coast Community Bank. This dispute before you today is a dispute over title to real property. And record title in the case is undisputed. In fact, both parties look to the same root of title, which is a certificate of title that was issued after foreclosure sale, as being their basis for title. Both parties recognized that there was a mortgage foreclosure that foreclosed out all interest that existed up until the time of the foreclosure of the mortgages themselves. And the case law makes it very clear that that established as it existed at the time the mortgages were issued. The foreclosure judgment says, which is typical, on the filing of the certificate of title, defendants, and then it names them, names every person who claimed an interest in this property, shall be foreclosed of all estate or claiming the property. Now this language of foreclosure applied to a property that had intended to be developed, but had not been developed as of the time of the foreclosure. It was a failed property. There had been some development on the property, but none of the lots, they contemplated that there were going to be 12 townhome lots. Not a single lot had been transferred to the ultimate owners. In fact, all of the lots belonged to a corporation, a corporate entity, Jesse Rush Enterprises, who held by a quitclaim deed that was issued after the mortgage was recorded. And that's his interest, of course, was inferior to the mortgage holder's interest. The Mortgage Investors of Washington case is a case that is virtually identical to those before the court.
Okay, I don't know about the other members of the panel. I have no problem saying that the foreclosure extinguished, pre-existing rights. Seems like the crux of this case goes to the deed issued to the Stearns, and it talks about deed declaration. And I go to that word, deed, because what I'm really getting hung up on here is, subject to covenants and easements of record, that's normal language. But this specifically said deed declaration. And that leads me to believe, or would seem to lead me to believe, that you are conveying that property. You need to look at this particular declaration here. So how do you get around that?
Well, Your Honor, first of all, I do think that is the absolute focus of this case, is what effect, if any, did the subject to language have. And so I'm glad you just directed me right to that point, because I do think that is the focus. I will point out that the Sterner deed, which is a warranty deed, contains the following subject to language. It says, subject to drainage easement to the state of Florida, subject to easement to Chalco, recorded, subject to restrictions, recorded, subject to declaration of covenants and conditions, easements, recorded. It has four subject to notations in it. Did those subject to notations create any interest in real property? Or did they do nothing more than refer the buyer of that property to the fact that there's record documents that may or may not have any legal effect whatsoever? The case that really addressed that issue, Your Honor, was the Prosaki versus Zacco case, 4th DCA 1975. In that case, the appellate court points out right at the very beginning that there is had not been much discussion in Florida on that issue.
Okay, if the easement or the declaration had actually been attached to the deed here, you would concede that would create easement, correct? I mean, pretty much.
Well, Your Honor, it could have if the conveyor of the title had expressed had wanted to. It wanted the declaration to govern his property. Could have re-recorded the declaration. I mean, we have to look at that declaration and what did that declaration do? I mean, first of all, it was from the entity that was foreclosed out. Secondly, the declaration had an intent within it that it didn't do anything as to the property that is before the court here today until the developer let go of it. And the developer says, I'm not going to let go of it until I convey the first lot. And when I convey the first lot, I'm going to create a homeowners association, never created. And then I'm going to convey the property to the homeowners association. Never happened. So the mortgage investors case,
I understand that the homeowners association is made up of the individual owners. Don't they have the right to rely? I mean, I'm having a little cross. Don't they have a right to rely that what's in that declaration is going to be, upheld?
well, John, let's look at mortgage investors. There was a homeowners association created by the developer. The developer developed a recreational facility, conveyed 800 lots to individual people. They were using the recreational facility. All of this was occurring before the mortgage foreclosure. There was a mortgage foreclosure. The bank, during that time period, clearly knew that all this was happening. In fact, it was giving partial releases as these 800 lots were being sold from its mortgage. It foreclosed on the property. It then comes in and still allows the individual owners to use the recreational facility. In fact, the bank, after taking title, comes in and renovates the recreational facility and then asks the individual lot owners to contribute a maintenance fee to the facilities, in which they refused. So what did the developer do? He closed down the recreational facilities altogether. He said, that's my property. Well, gee, isn't there stronger equities than existed in this particular case? Where not a single lot had been transferred. They all belong to the developer. No homeowners association had been created at all. And the much stronger case in mortgage investors than what did the court say? The court said in the mortgage investors case that you have to go back to the deed. And this bank did not join in the declarations. Same facts that are before you today. This bank did not join in the declarations. And the court held that the rights of the mortgage holder trump the rights of the homeowners association. Why? Homeowners association was created afterwards. He never joined into the declarations. That case is much more compelling, mortgage investors case, to finding some sort of implied duty by the subsequent taker of title at a bank foreclosure sale than the facts that are now before this court.
And counsel, and I understand you don't concede this point, but to the extent that the language of the deed is construed as being ambiguous and the court's looking at extrinsic evidence, Mr. Sterner testified he was at the foreclosure auction and he received a copy of the declaration and that a representative of Vanguard announced that the units were governed by and subject to the declaration. And based on our review of the record, there was no testimony from Vanguard refuting that point. So, again, if we go to the point where and I know you'll argue against the ambiguity, but if the court were to find an ambiguity, what standards should we use in looking at that evidence and determining whether, in fact, those representations were made and whether the Sterners can rely upon them?
Your Honor, first of all, I pointed out the Brasacco case goes through a litany of other decisions in which it looked to the subject to language. And they all found that subject to language was nothing more than a warning to people. It was a saying, hey, there's something of record there, and we're not warranting against it. Whether it has any effect or not, we don't know. And all of them said, the fact that you reference that document doesn't give it any validity whatsoever. And if you reference a document that has no validity, such as a foreclosed out declaration, it has no meaning whatsoever. So there's no ambiguity there. And ambiguity wasn't even argued in the court below. That was not an argument that was made, and it's been made the first time on the bill. They argued that everything was clear, there was nothing ambiguous, and therefore it should not be heard of appeal. The other point of that is oral representation by Vanguard, a remote party in the transaction, is that real estate transactions have a dignity unlike any others. And the court in the D.K. Delaney case, the Supreme Court, canvassed this issue. Went back 400 years. They go back to the 1600s when the Statute of Frauds was passed in England and talked about the purpose. They talked about it being in this state for 200 years, unchanged, and how that we need certainty in real estate transactions. And you don't have certainty if someone can come back and say, well, the person I bought it from many years ago said this, and this about the title. If you allow title to be altered by oral representations, I don't care if there's 200 witnesses that they were said or not said, then you take away the certainty of real estate transactions. Therefore, you take away the rights of mortgage lenders who lend based on the status of title, record title. You take away the rights of buyers, such as Gulf Coast Community Bank here, who acquired this property in reliance on record title. And that record title has nothing about promises that
Now, clearly we can't let oral representation impeach clear title of record. Again, I'm going to go back to Judge Rowe's question. And I know ambiguity, but if there is ambiguity, shouldn't the court be able to look at oral representations?
what Your Honor,
I'm asking a general question and not, related to this.
I understand, and you're not saying there is, but if there is ambiguity. Your Honor, there was one case that was cited in which such an ambiguity existed, and that was cited by the appellees. The Bell versus Seika case, 5th DCA 1990. And in that particular case, the deed says subject to a right-of-way across the east 30 feet. Now, there hadn't been a formal easement on that. It's just a subject to language within the deed. In that particular case, the court goes back and it looks to the contract for sale, which was executed with the same dignities under the statute of frauds, signed by the party against whom enforcement is sought, witnessed by two parties. And they said the contract made it very clear that an easement was intended, but the contract satisfied the statute of frauds itself. That's the only case that has been cited in which it found that a subject to language could create any ambiguity at all. You would have to, the subject to language doesn't preclude someone from arguing easement. The subject to language does not create an easement or any other right to property.
If they're saying the declaration here is what creates the easement, then
If the declaration had been performed, Your Honor, if an association had been created and the land had been deeded to the association, yes, there would have been an easement. That didn't happen. The court recognizes it didn't have the power to compel Gulf Coast Community Bank to create an association to the property, but then he fashioned an equitable remedy which forced the same result on the bank, which took that title with the title showing that the declarations were not part of the title. Thank you.
you're down to that 2.5 minutes. I'll give you an extra minute on the button.
Thank you.
We're not sure about 3.5 minutes.
Thank you.
We do have 1 minute to the Applebee's side as well.
Good morning, Your Honor. May I please the court? Heather Kennedy, the appellees, Robert and Tom Sterner. Your Honor, I want to spend a moment talking about this ambiguity issue because I think to some extent, appellants are getting up on board. What my clients pled below was easement by implication. By its very nature, implication suggests ambiguity. In other words, if the easement is not expressed, if there is something, there's a glitch in the easement, there is a way through the common law to look outside of the expression itself, to examine the intent of the parties, the surrounding circumstances, and the situation of the property. There's extensive case law on this. In fact, one of the best explanations is in Judge Coward's dissenting opinion in Moorings that was approved by the Supreme Court. And it talks about implication by a duly executed instrument. Interestingly, if you look at Procacci, which is a case that the appellants rely upon, even that case, in discussing the term subject to, references the concept of ambiguity. Subject to creates a condition. What it says is subject to the declarations. The reality here is this. The Sterner's deeds, which were the operative deeds, referenced both the plat to Sunset Villas and referenced the declarations. It is, in essence, an attempt by the appellants to say the extent to which clarity was sought is going to be used against the Sterners, and that doesn't seem appropriate, particularly in equity. The reality is this. There is continuity and intention throughout. Sunset Villas developers intended to create a townhome community, intended that community have common areas available for all the residents, parking, a pool, lakefront access. open areas. When that was foreclosed, and it was conveyed to Vanguard, Vanguard then undertook to rely on the same plat and the same set of declarations when it conveyed property to the Sterner's predecessors in interest and to the owner of Lot 3. That same common predecessor in title, Vanguard, then 30 years later conveyed a quitclaim deed, then it was Synovus, to GCCB, giving GCCB any interest it then had in the common areas. Now, to one of the other points the appellants made, there was no formal homeowners association, obviously, before 2013. However, in addition to representing the declarations would be operative, Vanguard then asked my clients to contribute. In other words, there was a de facto relationship. There were property owners, the only property owners at Sunset Villas at the time that had residences, were paying for the upkeep and maintenance. And again, this operated this way for 30 years. Everyone was on the same page. Everyone had the same intention. The property was situated as such that if you read it so that you only had a right to the lot that you owned, you couldn't go out your front door. That makes no sense. If you look at the case law, and what the trial judge, I think, said was, there's an express easement here. That's not exactly what my clients had pled initially, but what happened was there was an express easement because the deeds, the warranty deeds to the Sterners, included both reference to the plat and a reference to these very specific declarations that created common areas, defined them, specifically laid out an easement of use and enjoyment.
Well, counsel for the appellant makes a very good argument in terms of certainty in the chain of title. How is a good faith purchaser of, let's say lots, make sure I have this correct in the record, 8 through 12, to know that there's this burden of a declaration, and if you look at the plat, it doesn't, to put that buyer on notice that these common areas are owned by anyone, really.
Well, I think there are two things going on here, if I can sort of address it both ways. I think anybody who purchases lot 8 through 12 expected to purchase lot 8, lot 9, lot 10, lot 11, lot 12. To the extent there's common area that's used and enjoyment to their benefit, that would be a good thing, right? That would be something they would want. And I think part of this, when the case law talks about situation of the property, common sense comes into play here. If you look at a plat of a townhouse community and you understand generally what that is, it's not the same as that, I would argue, the same as a regular plat of a regular neighborhood. You expect communal areas. But I think the other thing is, this isn't about the bank's purchase of lots 8 through 12 necessarily.
I'm not sure the record's clear on this, but this was kind of a follow-up question. Somebody that's buying this property.
Excuse me, Rebecca.
Somebody that's buying lots 8 through 12 in the
Yeah.
common area. If they did a title search, what would they pick up?
If
Would they
they
pick up
look
the
at the conveyance.
declaration necessarily? I don't know. I mean, I'm asking. I'm not sure the record's clear.
I don't know that the record's clear, Your Honor, and I don't know that a title search would have necessarily reflected it. I suspect it did because I believe that's how the appellants discovered that the common areas had never been properly conveyed to a homeowners association, and went to Synovus and asked for a quitclaim deed, and Synovus requested a hold harmless agreement when it so conveyed it.
And I'd like to give the homeowners association, because we can certainly envision many situations in which a condominium townhome development is developing hundreds of units and they're not selling for a few years. Where does the property right vest until a homeowners association is created when there's a similar declaration to what we have here?
Usually, there is a problem here because the declarations provided, and generally the declarations, my understanding is declarations would provide when the property conveys to a homeowners association. So here, that should have happened when the first lot was conveyed to the Sterner's predecessor in title. And it didn't. The bank, though, in its actions, undertook to act as a homeowners association for a number of years. So I think you're stuck in a place where the property owners operated under a certain set of understandings with the bank. It's not like one didn't know what the other was doing. The common area was maintained. It was upcapped. The pool was built. And so there's some discussion in the record below about there being a de facto homeowner association. I believe the trial court even found that. And I think that was the realities of this circumstance. I'm sure there have been other circumstances where there have been foreclosures on developed property. One of the cases that the appellants relies upon, mortgage investors, created a different problem, I think, and I think it's factually distinct, simply because the homeowners weren't seeking to have, the property owners weren't seeking their right to have access to all the common areas. They wanted mortgage investors to pay in perpetuity. In other words, we know we're supposed to contribute, but because you can never convey to the homeowners association because this problem has been created, you always have to pay.
And so that gets me back to, to Gulf Coast Community Bank. Again, they don't know if this de facto, at least the record doesn't reflect that they know the de facto homeowners association. So even if they were to look at the declaration, they're not going to find a homeowners association that has title to this property. So, how do we deal with that?
Well, I think the problem here is the declarations were recorded, and they were recorded contemporaneously with the plat, within about a month of each other. So they are in the chain of title somewhere. And I would also point the court to a case where that was discussed as an issue because in Spencer v. Weiger, there was a plat and a replat. And what the court said there is when there was a common predecessor in title, which here would be Vanguard, now Synovus Bank, when Vanguard conveyed to one set of property owners with certain expectations and the restrictions and the declarations and the easement, it could not then quit claim to GCCB more than it already had. And once it conveyed an easement to the Sterners, it no longer had the ability to convey the common areas. Again, this isn't about law safety control, it's about the common areas. It had no ability to convey the common areas without the easement. To your point, and I think it's well taken, you do walk a fine line with everybody's expectations, what's recorded, what's available, but the reality is these declarations were recorded. There was a foreclosure, but I think you can go back in the chain of title and find everything. So that in and of itself allowed for an express easement, or if there wasn't an express easement, the case law talks about easement by implication by looking at everyone's intentions. And I understand the concern for purchasers, bona fide, innocent purchasers who come after. But we also have the problem of people who purchased property 30 years ago, have been paying to maintain, to upkeep. I'm sure if somebody went out and looked at the property, they would see that in fact the property had been maintained, it had been mowed, it had been improved. There should be a question. In other words, and the other thing is the plat always went. While the declarations may not have been joined by the original mortgagee, the plat was. So the plat was a record and part of the chain of title. Your Honor, turning to my third point, we had no adequate remedy at law here. I understand.
Before you leave the plat, I looked at, there's no reference in the plat to the declaration.
No, Your Honor, there is not.
And doesn't the plat act require that? I mean, there needs to be more clarity than there is in this case.
Yes. Well, and that's where I think the plat act is helpful in that it gives you an out. If you have it clearly written on the plat, it applies and it should be there. Excuse me. But when the legislature passed this plat act, there was all of this common law that allowed easement by implication. And I do agree with the appellants. If it was just oral representations and not based on duly recorded instruments, we would have a problem.
But it's not. I understand your argument, though, because easement by implication, in order for that to be triggered, requires ambiguity. And where's the ambiguity?
The ambiguity can be built, or at least there's an argument that I don't believe it's ambiguous. I think our position is, and that's what the trial court found, is it's not ambiguous. If there's an ambiguity, it's created by the fact that the Plat Act requires that it be written on the plat. And so to the extent it's not clearly written on the plat, I think the trial court's concern in also finding easement by implication by a duly executed agreement was to say, all right, fine, if there's an issue because the Plat Act should have been read according to the Plat Act, it needed to have something on the plat, then I'm going to look at the subject to language. I'm going to look at the surrounding circumstances, the intentions of the parties.
This read subject to any declaration of record?
I'm sorry, Your Honor, I missed the first part of that.
Okay. I'm a little concerned here because
Okay.
partially to me, one of the keys here is the word the.
Mm-hmm.
And I'm a little nervous about saying that word the creates an interest. So in order to clarify in my mind, would you have a case where this is subject to any declarations of record?
I don't think we would have as strong a case, but because easement by implication permits looking at the bigger picture to see the extent of the easement, I would agree our case wouldn't be nearly as strong. I think because it references specific declarations that everybody pretty much followed, that's a different case.
Because that's common language, look at any, somehow that creates an interesting title.
Well, I think it goes both ways though, and again, this is an equitable proceeding, is what did everyone expect? What McCorkadale and the cases that have been overruled since the passage of the Cloud Act in 1971, what they say is common honesty requires, what did everybody expect when these deeds were conveyed? Clearly, from the undisputed evidence in the record, what was conveyed to the Sterners was an easement of use and enjoyment of the common areas of the property. When you get to GCCB, as the second party that takes from Synovus/Vanguard 30 years later for whatever interest they had in the common area, that becomes a question of if the Sterners had an easement of use and enjoyment, then what got conveyed to GCCB were the common areas with a reservation for the easement of use and enjoyment for the property owners. Now, that also gets to the question of, I know the appellants mentioned it, how the trial court chose to resolve this matter. The Sterners asked that the actual deed be conveyed to the homeowners association, and that hasn't happened here. I think what the trial court was trying to do was fashion a remedy that made sense and to maintain the status quo. So what has happened here is that instead of conveying the deed to the homeowners association, the replat has been rendered null and void. And by that protects the easement of use and enjoyment that required the permanent injunction in the first place. And so I don't think the trial court abused its discretion, and we would argue that the trial court did not abuse its discretion when it chose to use that remedy to resolve this problem.
Almost seems inconsistent, though.
Well, I guess equity sometimes can feel that way, but I think the question is, at the end of the day, was the right result was reached. The bank hasn't lost the deed to the property. The bank still has what it got from Synovus, which was whatever interest Synovus had in the property. That's what it bargained for. And again, there was a hold harmless agreement because I think there was a question there of what was available. And the Sterners, who've owned this property for over 30 years, along with their predecessors in interest, have maintained it, have participated in it, and understood they had a conveyance of an easement of use and enjoyment, makes the most sense. And this, again, this is a townhouse community. The lots 8 through 12 ever got built. My assumption is anybody who bought those lots would want to understand that they had a right of ingress and egress. They had a place to park. And they could actually walk behind their townhouse onto the grass. Because the way the plat is laid out, they only get locked lots if you read the plat that way. And that, again, gets back to the situation of the property. It doesn't make sense any other way. And the plat carried through from the beginning to the end, no matter what party you're talking about, because the mortgagee did join in the plat at the beginning in 1985. Your Honors, for the following reasons, we would argue and request that the trial court's issuance of permanent injunction be affirmed. Any more questions?
Thank you.
Thank you.
Mr. Fleming, I'm going to ask, before you get started, you ask a question that's kind of concerns me because the record here is not clear. Would not a title search of this property, since there was a common grantee and there was a declaration of bond, a unified piece of property, wouldn't a title search, and I know you're going to say this is not dispositive, but I want to make sure in my mind, wouldn't a title search have revealed the declaration?
Absolutely, Your Honor. I believe it is dispositive for what the title showed. That's why we mapped it out here. It would also show that Jesse Rush and Dawson Baker once owned this property. That'll still be there. In fact, every transaction from title from the Spanish land grant forward would be of record And so a title searcher who looks at that record has to say, what is of record and effective as of today? There could have been a claim of lien there, for example, that was allowed to stay there 12 months and expired. It's of record. You may even reference it. You may say subject to claim of lien, but you don't create any rights. So we look and we say, here's the deed, and it's undisputed, there's only one deed to the property that's in dispute, held by either one of these parties, and it's by us. And so what would a title searcher find? Well, he would find that our title came from Vanguard, that Vanguard's title came from a foreclosure judgment, that Vanguard's title came from a certificate of title. He would trace that all the way back to the mortgages. What does the foreclosure do? It puts status as it was as of the day of the mortgage. What does it mean as to this quitclaim deed to Jesse Rigby Enterprises, Inc.? It is no more. What does it mean as to the declaration of the never performed declaration? It is no more. So, yes, it would be, what title would show is what we are claiming. We're claiming title to that property. That's what a title search would show. Now, did the Sterners know that? Well, they knew that as a matter of law, but they also knew that actually. They knew that no homeowners association had ever been created. They knew that no deed had ever been made over to a homeowners association. And so what was the effect of the court's order? Well, we're going to pretend that the declaration is valid, and we're going to give you the same rights that the declaration would have given you. Now, how do you distinguish that from the mortgage investor's case? I mean, this court certainly has the right to enter an order that's totally contrary to mortgage investors, but I would submit to the court that that was very good rationale, very good reasoning, because the taker, the buyer of that property has rights too, and he has the rights to rely on that title. On the implied easement issue, that issue was put to death, put to rest by the Supreme Court in the D.K. Arena case, and in the other cases that we cited to, and especially Tortoise Island Morning's case. That was put to bed, and it says you can't give rise to an easement without satisfying the statute of frauds issue. In the Tortoise Islands case, there was a case in which the developer had told, both verbally and in written brochures, that I'm giving you the rights to this canal forever and ever. Amen. He even put it in some of the deeds, saying, giving you the rights to use of this canal and all other owners' use of this canal. And then the property changes hands, not through a foreclosure. I mean, it's a weaker case than our case. Not through a foreclosure, but just through a deed. And the new owner filled in the canal. And when he filled in the canal, the people had no rights of ingress, egress, and the court says there was no easement, because you cannot create an easement through oral or written representations that do not satisfy the statute of frauds. Thank you, Ron.
Thank you, Ken. Thank you for Will arguing case on both sides. You've enjoyed our stay in Fort Walton Beach.
That's true.
Thank you to the court for coming to Fort Walton Beach and to our areas. I know that's inconvenient for you. I know that means you have to pack up your bags and come and stay, and we really appreciate it.
No, we enjoy it. Thank you.
Okay.
Thank you for protecting us.